Make sure you guys can hear me.
Thanks, Tony. I think that that project is kind of a mixed.
Good evening, Tommy. We can hear you.
Okay, thank you. And it sounds like we're already recording, and I apologize for the 1 minute being tardy. I was having Zoom issues. But if you're good on your end, I'll get going. Is anything else needs to happen in the hearing room, Mr. Miller?
We are ready to proceed.
Okay. Let me proceed then. All right, we will go on the record. The time is 6:01 p.m. and this is the hearing for Deschutes County file numbers 24722-517MC, 24722-518SP, and 24722-961MA. My name is Tommy Brooks, and I am the hearings officer in this matter. Before we turn to the substance of the hearing tonight, I'm going to turn things over to Mr. Miller to describe with a little bit more detail what the format will be. Mr. Miller.
Thank you, Hearings Officer Brooks. Good evening. For the record, my name is Nathaniel Miller. I'm an associate planner with the Deschutes County Planning Division. The item before the hearings officer tonight is a request to modify the previous conditional use permit and site plan approvals for the Redmon Rod and Gun Club. Today's hearing will proceed as follows. First, staff will explain the hearing format and how to testify at today's hearing, followed by a brief presentation on the application. Then the testimony portion of the hearing will begin. The applicant will present first, then agencies. Next, persons in support will testify. Then those in opposition will testify, and anyone neutral to the applicant's request will testify last. Afterwards, the applicant then will be afforded an opportunity to present rebuttal testimony. And finally, staff can make any closing comments. This is a hybrid public hearing with both in-person and remote participation. Before starting your testimony, please provide your first name and last name as well as your mailing address. For our in-person participants, if wishing to testify, please add your name to the sign-in sheet located near the door. I will use this list to call up participants for their testimony. After your name is called, please come up to one of the tables at the front of the room before beginning your testimony. For our remote participants, if you want to testify, you must be logged into Zoom or have called in using the Zoom dial-in option. When Hearings Officer Brooks asks if anyone attending remotely would like to testify, you will need to use the raise hand feature to notify the staff. To do this, you need to press the raise hand button on your computer or smart device, or if you called in, dial *9. In addition to oral testimony, if anyone has written testimony to submit, please hand it to me directly. If you are in person, please submit your written testimony to me after your testimony. If you are participating remotely, you can submit your written testimony to me via email at nathaniel.miller@deschutes.org. Hearings Officer Brooks and staff are responsible for conducting an orderly hearing. Any testimony or behavior which is inappropriate will be addressed and may result in that member of the public being removed from the hearing. At this time, I would like to ask if there are any objections to the format of the hearing. If you are attending remotely and have an objection, please use the raised hand function. Seeing none, I will turn the hearing over to Hearings Officer Brooks.
Great. Thank you, Mr. Miller. And as Mr. Miller just described, we are following the normal hearing procedures that are set forth in the county's code. That will definitely provide sufficient opportunity for everyone to participate at the appropriate time. The application is being considered through a quasi-judicial process. As such, I will consider only the factual evidence that is in the record, and I will apply those facts to any relevant provisions of the county's comprehensive plan and land use regulations. The standards and the applicable criteria relevant to this hearing were identified in the public notice that announced the hearing. They are also set forth in the staff report. The public notice and the staff report are posted on the county's website and are available directly from staff upon request. It is important that you direct all of your testimony to the standards and applicable criteria. If you believe a criterion applies that was not listed, you may address the unlisted criterion. However, I urge you to also explain why that criterion must apply and to do so with specificity so that other participants may respond and so that I can address that issue in my decision. The failure to raise an issue with enough detail that enables me or the other participants to respond will preclude your ability to appeal that issue to the Land Use Board of Appeals. Also, the failure to raise a constitutional or other issue relating to any proposed conditions of approval, again, with enough detail that allows me to respond to the issue in my decision, precludes an action for damages in circuit court. As noted, I serve as the county's hearings officer. In that role, my job is to be a neutral decision maker. Thus, while I have a contract with the county to serve in this role, I am obligated to remain impartial, and I do not represent the county's interests or the interests of any other participant. To that end, I will state for the record that I do not have any relationship with the applicant, and I am not aware of any connections that I may have to other participants in this proceeding that would prevent me from remaining impartial. I do not have any ex parte contacts to disclose. I have communicated with staff, but only to discuss the particulars of today's hearing and not the substance of the application. It is my obligation to preside over the hearing in an efficient manner. I know there were a lot of comments that were received in the record, but before I determine if I'm going to set time limits tonight, I'd like to determine how many people are signed up to actually testify, both in the hearing room and online. Can you help me with that, Mr. Miller?
Absolutely. We're checking the list at the door right now. We are seeing 8 people online who would like to testify. And we have 6 people in the room who would also like to testify, so a total of 14.
Okay, thank you. With 14 people, we're right on the bubble, I would say. I don't feel compelled right now to set time limits. I will just go ahead and ask everyone to really take to heart the part of my earlier comments that you need to address that criteria. If you're just here for general support or general opposition, that's not useful. It's not a useful way to spend everyone's time. So please address the criteria. And if someone before you has addressed those criteria and you agree with them, there's no need to repeat that. You can just say that you also, you agree with the testimony of that particular person, and we should be able to move through that pretty easily. So we will move on, assuming no time limits are needed, but I will reserve the right to get people focused if we have to. Before we begin, does anyone wish to challenge my ability to hear this matter or to challenge the county's jurisdiction over this matter? And if you're online, you can note a challenge by raising your hand.
We are not seeing any objections.
Okay. So with that, I'll turn it back over to you, Mr. Miller, to deliver the staff report.
Thank you, Hearings Officer Brooks. The subject property is comprised of tax lots 101 and 700, and together approximately 225 acres in size. The property is approximately 3.5 miles to the south of the city of Redmond on the east side of Highway 97. As noted in the application materials, the club intends to discontinue the use on tax lot 101. Through the modifications of conditions and site plan review submitted in June of 2022, the applicant requested to identify and relocate shooting disciplines on tax lot 700. These shooting disciplines were discussed in the previous land use approvals, but never were fully articulated on the site plans. The previous site plans are file numbers CU0917 and CP0911, and also file numbers 247, 15, 263 CU, and 264 SP. These approvals span both tax lot 101 and tax lot 700. In September of 2022, the applicant requested to relocate the entire club onto tax lot 700. The applicant submitted a modifications of application in support of this request on December of 2022. Up until the decision for a public hearing, staff received no public comments to the record in support or in opposition to the proposal. After the public hearing was scheduled and notice sent on March 14th, staff received numerous public comments of support for the application. As of 5:30 p.m. today, we have over 90 plus comments in support of the applications. Staff has not received any comments in opposition. Staff would like to note that all the application materials, notices, as well as public and agency comments are located on the proposal webpage. This webpage can be accessed through the Community Development Department website and the web address listed on the screen. Also, staff notes that there is an incorrect code reference on page 9 and 71. In the staff report, the reference to Deschutes County Code 22-23040 should read DCC, or Deschutes County Code 22-36040, which is our modification of application criteria. Lastly, since the staff report was not issued 7 days in advance of the public hearing, staff recommends an open record period of 7, 7, and 7. This concludes the summary of the proposal. Staff is available for questions.
Thank you, Mr. Miller. I do have a couple questions for you, just in aid of understanding the staff report and some of the questions that were posed to the hearings officer. But the first question I actually have is on the land use history, and this is on, I think, page 4 of the staff report. For both tax lots, there's a reference, I guess, in 1978 for a plan amendment and zone change. I couldn't tell if those were sort of what those were and how that resulted in the current zoning, which I understand to be EFU. Can you help me decipher what that plan amendment zone change application did in 1978?
Sure. So the record is a little thin back at that time period, but by my research, it appears that this was never enacted. And in fact, the plan amendment zone change that happened was before current county zoning, which classified the land as exclusive farm use.
Okay. All right. Just so it was an application, but as far as we know, it doesn't have any effect on the EFU designation that's there today.
That is correct.
Okay. I guess a bigger picture question I have for you is, and this is just, I'm juxtaposing some of the comments that were received kind of late from the applicant in the past couple of days, responding to the staff report. But I think one of my tasks here really is to figure out what the applicant is requesting to be modified. But there was some comment in the applicant's responses that maybe staff was, quote, relitigating the 2015, 2016 decision. I don't necessarily read that in the staff report. I see an acknowledgement that the use as a private park was established. So instead of doing it at the end, do you care to comment about sort of what staff's position is on what the scope of the application is and in terms of what's being presented to me, if it's the use or just the site plan?
So both are being presented to you as the hearings officer. So I can speak in general terms just to provide some context. So when the county receives a modification of conditions that will alter previous site plan approvals or conditional use permits, the applicant typically demonstrates through an application that they meet the modification criteria, which is in our code as Deschutes County Code 22-36040. In addition, they also modify any of the relevant criteria that's listed in the previous land use approval. So to give you an example, non-farm dwelling. If someone came in to modify a non-farm dwelling, they'd meet the modification of the modification of conditions approval criteria, and they would also alter or modify the approval criteria for a non-farm dwelling that are found underneath our local code provisions under 1816-050.
Okay, so the way it's presented then, you feel, or staff feels, that in order to make a decision on this application, that I need to both determine that the use is allowed and that the site plan fits the site plan criteria?
I think from staff's perspective, what we're asking of the hearings officer is best stated on page 9 of the staff report. staff is requesting direction from the hearings officer on the implementation of Deschutes County Code 2236040, which is our modification of approval criteria for the subject proposal.
Okay. Thank you for pointing me to that reference. I will look to that. And then the last question I have for you, and this is from the staff report, and it's a little bit more specific. Just there's one of the site plan review criteria looks at the installation of above ground utilities, and staff has a note in there that a solar farm, that you consider that to be an above ground utility. I wonder if you could flesh that out a little bit more, if that's the kind of sort of what the source is of that position, that it is a utility, but more specifically that it's the kind of utility that's covered by the site plan review. And I guess what I'm grappling with is the distinction between a solar farm as a use versus a solar farm as providing a utility to the use.
Yeah, and staff doesn't have a clear answer for that this evening. I'd be happy to provide a staff memo which details that. I did look for direction from our title and definition section, Deschutes County Code 1804, but I didn't find anything that specifically addresses that. But I did have my staff report reviewed by senior planning management, and they both agreed with the way that we have this positioned in there as a above ground utility.
Okay. Thank you. I may take you up on that offer to provide a little bit more detail. I'll probably have some questions for the applicant that might flesh that out. So I guess stay tuned. That's all the questions I have for you, though. We can move on to the applicant's presentation.
Thank you. My name is Ed Fitch, 210 Southwest 5th Street in Redmond. I'm the attorney for the applicant. And the first thing I'd like to do, hearings officer, is to kind of go through the history of this modification. It was not initiated by the applicant. It was initiated in some respects by Deschutes County. In the late summer of 2020, almost 2.5 years ago, the county requested a meeting of the Redmon Rod and Gun Club to go over the site plan and the current use of the property. And at that meeting, which was attended by senior management from the county administration and planning, as well as the president of the gun club, and Carl Notu, as an engineer who had worked with the club for some time, we were requested to just provide an updated map showing the current locations of these uses that were approved in 2016. So between 2006 or 15, when the uses were approved and I'll call it a very rough site plan approved, the club proceeded and did change the location of some of the uses for safety purposes. And so in the summer of 2020, we agreed that we would come up with a new map showing the current locations of the uses for these various disciplines. We proceeded on that basis, and then we were requested sometime in 2020-21 to early 2020-22, not only should we show the current locations, but we should provide information to Deschutes County that these locations were safe for operation, not only for the users in the location, but also on adjacent properties. So the applicant hired AKS Engineering, Paul Stoll, who did a very detailed study of the site. He found a couple of improvements that would help, and those improvements that he identified were put in place by the applicant. But his study shows that the current use of the facility in these current locations are safe, not only for the people on the property, but also for adjacent properties. He also helped the applicant develop a conceptual plan. And the reason for that is that the county staff had said to the applicant that it would be helpful to have a plan of where the club and the public saw this use going forward into the future, so that we would not have to come back time after time on any kind of modification, but only we would have to come back for building permits if there were new buildings to be put on the site. And so AKS Engineering worked with the gun club to come up with a conceptual plan, which is in the record. And they also studied the conceptual plan and found that these uses in the plan going forward to be implemented at a later date would also be safe in terms of industry standards, not only for the users of the property, but also adjacent properties. And I would say that between 2015, when this was initially approved, and today, there's not been one incident out there. There's not been any issues with traffic onto Highway 97. So the experience of the last 8 years supports also the finding that this use has been properly designed, properly used, and now the public, through this process, would have an identification of where those various disciplines were, which was the initial request by the county. In February of this year, we had a meeting with the county staff and administration. And the reason for that was we were kind of at odds as to how this was going forward. For example, in 2015, when this use and site plan were approved, there was no requirement for bicycle parking. There was no requirement for braille. And there were a number of other items that are in the general site plan criteria that were not really applicable to this use. You would not ever ride a bicycle to this property because you would probably get killed on Highway 97 trying to access it. You would never try for pedestrian access to this site because, again, Highway 97 is basically an impenetrable barrier for those two types of uses. You would not have braille on site because blind people would not go into a shooting range as a matter of general discourse. So there's a lot of commonsensical reasons why significant or not subparts of the site plan criteria were inapplicable to this use. And so, over the course of the 2 or 3 years from 2020 to February 2023, we kept having basically a conflict as to what the scope of this modification was. We did not believe it appropriate to open up a lot of those site plan criteria that were rejected in 2015 and apply them now because, again, they still didn't make any sense. So we did reach an agreement with the county administration and county staff that we would bring this to a hearings officer based on a very narrow scope of this modification. One, that we would identify the current locations of these various uses. Two, that we would provide a conceptual plan of the facility going forward into the future. And three, that we would document that these uses, both in the current site and into the future, would be safe, both internally and for adjacent properties. And so that's what we did, and we believe that is really the scope of this modification hearing, are those three items. And the county also agreed in that meeting, and which I kind of confirmed in an email, which is in the record, that they would not oppose this application and as to this scope and as to those three issues. So from the applicant's perspective, Mr. Hearings Officer, we believe that we've met the requests of the county that were started in September 2020 and evolved over time, that we have submitted a plan showing the current locations of the site as well as the conceptual plan going forward. There are two things I would generally note, and one is that the current use on 101 would probably keep occurring until the property is sold. We have listed the property for well over a year now. We thought we had it sold at one point, but then the deal fell through at the last minute. It's still being listed for sale, and we anticipate it will be sold sometime in the near future. We have identified the site on 700 where that discipline will be relocated, and again, as part of the conceptual and plan going forward. The last thing I would note is that in getting ready for tonight, in looking at the conceptual plan that Paul Stoll prepared, it goes from page 000 to page 010, 11, 12, 13, and then 020. And I was panicking because I thought we had missed some pages, but in talking with Paul just before coming here tonight, those are all the pages of the conceptual plan. With that, we do have two people to talk to you on behalf of the applicant. Phil Mitchell is to my left, and he's the president of the club. And then Paul Stoll's on remotely by Zoom, and he'll go over the safety aspects. So unless you have any questions for me, I'll be happy to turn it over to Phil.
I think I'll hold my questions until all three of you are done, and then we can go from there.
Okay, thank you.
Mr. Brooks, my name is Phil Mitchell. I represent Redmon Rod and Gun Club as the president. I know there's a huge amount of written information it's from the staff and from our legal representative regarding this application for the conditional use permit. But I wanted to give you a brief summation about the club, and I'd also be happy to answer any questions that you might have. Redmon Rod and Gun Club was established in Redmond in 1945. It was in a different location than it is now. The club is a nonprofit 401c4, and it's operated exclusively by volunteers. The club currently operates on 2 parcels of property, which has been mentioned in the report, off of Highway 97 between Redmond and Bend. One of the parcels of property is on tax lot 101, and that's made up of approximately 72 acres. And the other property is on tax lot 700, and that's made up of approximately 153 acres. The club's mission is to provide a facility to promote safe shooting sports for the Central Oregon community, club members, as well as visitors from throughout the state and the Northwest region. To fulfill our mission, the club has developed a variety of features and services. The physical ranges are made up of 7 different shooting sports disciplines. The shooting sport disciplines that we offer are sporting clays, 5-stand, rifle and pistol shooting, cowboy action, archery, and trap. Trap is the only shooting sport that is located on lot 101, and the ultimate proposal would be that trap would be moved to tax lot 700. These disciplines are controlled by specific directors, and those directors are members of our board of directors. They oversee and train and assist all of the volunteers that operate on that site. All of the volunteers are trained at the club in safety procedures prior to spending any time with the public or with range equipment. To the services that we offer, each discipline offers professional instruction for safe firearm operation and skills, outdoor youth programs, women's programs, support for law enforcement and other organizations such as Oregon Department of Fish and Wildlife and their youth and training programs. We work with the Boy Scouts, the Girl Scouts, 4-H, and the area high school shooting club, which is made up of 4 high schools in Central Oregon. The instructors that I mentioned are at the club are certified by national instruction organization programs such as National Sporting Clays Association, National Rifle Association, and Oregon State Shooting Association. There's other training programs involved. The goal of Redmon Rod and Gun Club is to continue to operate all of their exclusive activities on tax lot 700 and sell tax lot 101. The purpose of this would be to utilize the capital for improving overall operation of the club and enhancing the physical sites allowing the club to offer the best opportunities to serve Central Oregon, the state, and the region. The club has applied for this modification that was originally offered I believe in 2016, and we've demonstrated that we operate this organization in a very safe fashion, and we do not offer any risk to adjoining property or to the Highway 97. We are asking that this modification that was submitted be approved by the hearing officer. Thank you.
Thank you, Mr. Brooks. Just before calling Paul, I want to just note a couple of things. First, there are a couple of documents which the planning department has provided, the anticipated noise declaration, the conditions of approval agreement, and we've always indicated we're ready and willing to sign those. Also, there was a question in the staff report as to whether the access aisles on site were 24 feet or more in width, and they are. I think last I wanted to point out that the parking there meets the requirements and has always met the requirements of the site criteria. So with that, I would ask that Paul Stoll join in. He's on Zoom, and he is the engineer who did the safety studies.
Hi, I'm Paul Stoll. I am a licensed engineer in the state of Oregon. I have degrees in civil and environmental engineering from Oregon State. I have been providing range design and safety consultations throughout the United States for law enforcement, military, private clubs, and U.S. Olympic ranges, and have done numerous sites in the state of Oregon, including on the east side of the Cascades. So I was asked to provide the club with two things. A ballistic study to look at the safety issues, if any, at the site in its current configuration, and also in a master plan, concept master plan layout moving forward. So in doing so, I provided a conceptual design that consolidated range activities onto site tax lot 700, which basically moved the trap ranges and the 5-stand range over to 700 and reoriented and expanded some of the existing tax lot 700 activities to maximize both the use of the property and safety for the participants. So in the ballistic study of the existing facility, we found that there were two small issues. One was at Bay 8 at Cowboy Action, that if an errant round left the range, its elevation at the property line would be below the 20-foot standard. And so we made a recommendation to increase berm height and orientation of that bay, which has been done, which brought that elevation up above 20 feet. The other was a exclusion fence between Cowboy Action and the sporting clays. This provides users a barrier, a visual barrier not to go past, which is basically placed at a location where an errant round would be at 20 feet above the user, which is standard. The club has put in that exclusion fence line and signage to keep them out, so that has been remedied. Those were the only two issues that were identified during the current configuration study. Moving to the future concept design ballistic study, we used engineering parameters in order to alleviate a lot of the safety issues that may have come up. One example of that is that the trap range was placed in an orientation and with adequate distance in order to ensure that ballistic shot would fall within the property. So we did a study on projected maximum distances of various shot sizes that are accepted on the trap range, and those were between approximately 563 and I believe 625 feet. We use 700 feet as our max distance, plus there's an additional distance past that. So it was a conservative approach for doing that for the new location for those. We also designed the majority of the bays, the new bays in the master design, to be shooting to the east away from any potential future developments or expansion along Highway 97 and into vacant land, that if there was an errant round, not only would it leave the property at a very high elevation. I think the lowest one was in approximately 121 feet. The rest of them were well above that. So there wouldn't be any conflict with operations on the ground. And the landing on those would be far away from any developed property. And we used a maximum distance of approximately 8,000 feet, which is about 1.5 miles, which is conservative considering that most of the bays that would be shooting in that direction would be restricted to pistol calibers, which don't typically go that far or have a exit velocity that would allow them to travel that distance. So we try to use conservative parameters in the development of the concept range in order to maximize safety and utilization of the property. And that's basically the study in summary.
Thank you, Paul. In conclusion, Mr. Brooks, what I would say is that the only, I'll call it significant concern we had with the staff recommendations was a time limitation on implementing the master plan. As Mr. Mitchell pointed out, this is a nonprofit organization based upon volunteers. The conceptual master plan was done again at the request of the county, where they said that a master plan going forward would be helpful because you don't have to come back for any modifications so long as you kept in line with the master plan. You would only have to come back for any necessary building permits. And so we believe that there should not be a time limitation. This may take some time, but it gives everybody a guideline, both from the private side or the nonprofit side, as well as the public and the county, as to what is going to occur on that property long term. And then I think there was one other thing I wanted to mention. There was a response from ODOT about the indenture of access for where the new access is for the club, and subsequent to seeing that on the report, we have been in touch with ODOT and are working on that indenture of access, one that's already been approved but just needs to have the documentation submitted to ODOT. So with that, Mr. Brooks, I think we're finished with the applicant's report unless there's some questions.
Okay, I do have a number of questions I just want to kind of work through, and I'll try not to make it too tedious. You've addressed some of the questions I had. One was about access. I guess in general, let me start with the biggest picture question, which is, in the staff report, there's a number of proposed conditions of approval. It sounds like you have one concern with the 2-year implementation of the master plan. Are there any other, is the applicant okay with the other conditions of approval that staff has proposed?
If you give me a minute, I'll go through that and make sure. If you had other questions, go ahead.
Yeah, I'll try to maybe start with an easier one then too. The kind of keying off what I asked staff earlier about the solar farm. I know that that's on the conceptual plan for the master plan going forward. I understand, or I assume it's not a currently existing facility. I think I need more, I guess, detail on what that's for, how it gets used. Is it is it part of this use, or is it, kind of a separate use? Because of all the activities that I've seen that were part of the original approval, continuing forward, they all seem to be the same, except for this one kind of sticks out to me as being kind of a different, or in addition to the use. So I just want some more explanation about what that is intended to be.
If I may, I'll address that. we have no utilities, electrical utility or water utility on tax lot 700. We currently use solar power to generate all of our needs. We have installed I believe it's a 14-panel solar device. We have, that's currently through the approval of the county. The permit has not been finalized. I think we have until June to do that. And that's just to generate power for our usage on property. The conceptual plan that shows a solar farm, I think that's just a terminology. Once again, that would be just to supply power for usage on property, our Wi-Fi, our computers for our point of sale, et cetera, that sort of thing. It would not be anything that would have to do with reentry of power into a grid.
Okay, thank you. That's very useful information.
And yes, Mr. Brooks, I think the conditions of recommended, with the exception of that time limit, are fine.
Okay. Just taking a note. Okay, thank you. Other questions I have, I guess again, I'll try to start with the kind of big picture. The one thing I'm not tracking is sort of the review process, if any, that occurred between the last approval and the current site plan. So I understand, I probably can't share my screen, but I've got the site plan that was, part of Mr. Olson's decision. That's pretty grainy, and I think you acknowledge isn't that detailed. But I think what I've gathered from, you have another submittal from September 28th of last year that shows sort of the current site conditions, the current site plan, and those are different. So walk me through that. It sounds like some of the changes that were made from what was approved to what's out there now were safety related, but did that involve any review by the county? I mean, I'm getting kind of different signals about whether or not it was just sort of done informally versus whether it was done at all.
You're correct that between 2015 and 2020, for example, the Cowboy Action area was moved from the southeast part of the property to the southwest. That was not done in coordination with the county. That was, I'll call it our bad, but it was done for safety reasons. I think the other ones are pretty minor changes, not significant, but that was the one that was the most. Go ahead, Phil.
In addition, the most major one was the movement of sporting clays. The sporting clay map, I believe, that you have in front of you shows from 2015 in the northeast corner of the property. That may in fact be what brought this whole subject around to review. And that, even though it was approved, was creating a safety issue as far as shotfall off of property. So sporting clays was moved to the southeast corner of the property, which is shown on your both current map and on the proposed site plan. And that was done for one reason, and that is so all of the shooting on sporting clays is done into the center of that so-called circle, where before it was showing that it was being shot, the shooting was going to the north, and that's where the shotfall issue would have come about. So that is not only a safety issue for the participants, but it also contains the shotfall within the property. That would be the most major change.
Okay, thank you. This is helping me kind of crystallize, I think, where some of the issues might be. So, Mr. Fitch, the follow-up question to that then is, for purposes of this application, it feels like there's basically, it's almost like a two-part request. You are modifying the approved site plan from 2015 to match what's on the ground today. And then the second piece of it is, but you would also like a approval of a site plan that's more of a master plan that would guide it in the future. And so there's no, I guess, well, is that a fair characterization of the request?
Yes, that is.
Okay. And so then with that, and maybe this gets to your issue about the implementation time period. So there's, I guess, no plan and or requirement to immediately proceed with the conceptual plan that you could, if your request is approved, you could stay with the current configuration. The site plan would be approved, but if you wanted to modify the site over time, you could do so as long as you're consistent with the master plan.
So the idea of the conceptual plan or master plan, beside the discussion when we worked with Mr. Miller, who helped us work on this moving forward, is to create a situation where when you have turnover in a volunteer organization, we have a guideline that's going to keep people in told to what that the county wants us to do, rather than going off and just doing something that might seem like a good idea at the time. The footprint of what we have on the ground today doesn't change. So the concept is to refine what we have on the ground and do it according to the design that was created by AKS for moving forward in the future. And as far as the timeline is concerned, it's awfully hard to create any kind of proposal to the members or to the public for making this happen without knowing whether we're going to have this modification approved or not. So that would be in the infancy stage at best right now, and then depending on how this modification turns out, then we can start making plans for the future as far as the club. But it would be done based off of what the design is in the conceptual.
Just sort of sticking with this difference between what was approved, what's on the ground, and the what might happen in the future. I want to focus a little bit more on the difference between what's on the ground today, the site plan, and how it compares to the 2015 decision. So just sort of making my list here, I understand that the sporting clays range moved from the north side of tax lot 700 to the southeast side. The cowboy action range moved as well. Besides the shooting disciplines, did anything change in terms of, and I'm thinking specifically of the areas identified for parking, or any, I don't even know if there were buildings in the originally approved site plan, but is there anything that's unrelated to the shooting disciplines that's different that needs to be captured in sort of the current conditions approval?
I don't have the map from the 2015 or 2016 decision. My memory would tell you that we have increased the parking lot size on 700, as shown by the on-the-ground mapping. We, I'm sure, have a couple of more storage areas. We use Conex containers for storage. We would certainly have a couple more of those. But significantly, I could not think of anything that would be different than what would have happened in 2015, 2016.
Okay. Thank you. That's helpful. Let me check my notes. This may not be a fair question for you, Mr. Fitch, in sort of in the hearing, maybe something you could follow up with on writing, but I think two of the issues that are highlighted in in the staff report that I need to make sure that I get right are there's areas where the applicant basically has asked for either an exemption from the code or a variance. I think one of those is in the has to do with landscaping. Was one more, I'm struggling to put my finger on it, but it's definitely highlighted in the staff report. I guess what I'm trying to figure out is how to address those issues, because what the staff report notes is that there's been no application for a variance. That may or may not be required if there's some code basis for an exemption or an exception. I guess I'm just gonna be candid with you. My initial review through the record, I'm trying to figure out how I would address that without a variance application, or with some really solid information about why the landscaping standards, for example, should not apply at all.
So it goes again to the scope of the modification. We are not asking for a modification of the site plan on things that were excluded in 2015. And for very good reasons: landscaping, bicycle parking, pedestrian issues, braille for blind, were all accepted in 2015 in the site plan that was approved. None of those were required, and for good reason. If we look at tax lot 700, which I think is about 175 acres, probably 160 acres is still in natural vegetation. Further, there's no water on the property. There are COD water rights, but they're in the river, and they are probably going to be sold to COID because there's no really land that can be farmed on 700, and you couldn't farm it really for safety reasons. So there's no water. There's 160 acres of natural vegetation, and that's why landscaping was not required now, and we're not asking to modify that part of the site plan. There's no feasible pedestrian or bicycle access to the site from anywhere. And so that's why those were not required in 2015 in the site plan, and we're not asking for any modification of that part of the site plan. So instead of a variance or exception, what we're saying is that those conditions of the original site plan still pertain, or the lack of those conditions, because they were accepted, they were not required in 2015 for very, very excellent reasons. And so we don't think, because we're not asking for a change in that those should not be applied in this instance as well.
Okay, thank you. I think that's probably one of the keys to the application is figuring out what is being requested to be modified and what's not. I think the way that the code reads, if something is being modified, it will be subject to whatever standards govern that component. So I'm just thinking out loud here based on what I've read in the record. And for example, if in 2015 bike parking was excluded and your new proposal doesn't change anything about bike parking, I could see where that's not being reopened. That bike parking is not part of this site plan. You're not changing that aspect, so it's not up for discussion. But parking lots in general were part of the site plan, and it feels like there's an element of here that the parking lot is changing on the site plan. And so the site development standards that govern parking lots might be at issue. So I'm going to be looking for that to see. I have to resolve that in order to thread this needle of doing a site plan that's kind of capturing current on the ground conditions and compared to what's approved. But if you have a response for that, either now or in writing, it would be useful.
I do, and I think when you look at the conditions that were proposed by the planning department, they address some of those. And again, those conditions that are recommended by the planning department do not include putting in landscaping or bicycle. We do believe the parking requirement will be met and with what is on site now. If you want to make that, but a condition, I think it might be in one of the conditions prior to any issuance of any building permit, we have to establish that the parking's appropriate for that building. But the parking really, obviously it moved because of the safety concerns of the trap shooting going, or what was it, the trap shooting moving to the southeast, which forced the cowboy action to move to the southwest of tax lot 700. So the parking's there, it's just in a different location.
Excuse me, it's a move of Sporting Clays.
Or Sporting Clays got moved to the southeast, and then that forced cowboy action to the southwest.
Okay, thank you. Maybe the last thing I want to follow up with, at least now, is I think in your opening comments you mentioned that the tax lot, the activities on tax lot 101 would continue until the property is sold. That doesn't match what I guess read in the application, or at least maybe I assumed what was saying in the application, but the application felt like it was presented to go ahead and consolidate all the uses onto tax lot 700, and that there would be no use on 101. So can you confirm kind of what the request is? Is it to keep it in place, or is it to go ahead and consolidate it?
The plan would be to consolidate it as quickly as we possibly could for a couple of reasons. One is it makes it easier to manage as far as the overall operation. And two is that, as we mentioned, the tax lot 101 is for sale. And we're going on the assumption that if that property sells, part of the sale agreement would be to move that discipline off of that property. Well, the only place to put it would be onto lot 700, and it is shown on the proposed plan as to the location of where that would be. If the property doesn't sell, we would still want to move that facility to the other tax lot 700. Okay.
I guess the more blunt way to put it is tax lot 101 is either part of the site plan or it's not. And I guess if you get approval of this decision, do you need it to be on the site plan, or do you need it to be not on the site plan?
Okay, excuse me a second.
Take your time.
Our only obligation is through the end of May of this year
For,
this high school deal.
yeah, so if we had to the end of the year.
I mean, if this was a deal killer, I'd say shut it down.
Yeah, so I'd say to the end of the year or something be appropriate.
If that's accepted, that'd be perfect.
Yeah, so I think if there was a condition to move that by the end of the year, this year, that would be fine to give us the logistical time to do it.
Okay. Okay, I think that's all my questions for now. I appreciate you spending the extra time and engaging in the discussion. And you, of course, can come back up for rebuttal after we get through the rest of the testimony.
Thank you.
Mr. Miller, I think we're ready to call up anyone who is going to testify in support of the application.
Leave everything here.
Okay, starting with the individuals who are in person and would like to testify in support. We have three. Terry Gibson. Is it Brad Collin?
I think we both supplied in writing.
Yeah, we submitted written testimony. We don't need to reiterate it.
Okay, so
It's on the record.
you're both Terry and Brad.
Yes.
Okay, great. Brad Davis.
I did the same.
Okay. Tony Oliver. We have one person who would like to testify in support.
Okay.
She couldn't get her email working.
Yeah.
Good evening, I'm Tony Oliver. I live at 550 Northwest 74th Street, and that's in Redmond, Oregon. I wanted to show my support for this resolution. The thing of it is, and I agree that we need to have a clear demarcation between the two lots, and I think the process that the club has provided will make that happen.
Thank you.
We'll now look online for people who would like to testify in support. And nobody online would like to testify in support.
All right. Then we can move to anyone who signed up to testify in opposition to the application.
We are not seeing anyone who would like to testify in opposition to the application.
Is that true both in person and online?
That is for both, in-person and remote participation.
Okay. Well, that would bring us back to rebuttal. I don't know that there's anything to rebut.
I'm certainly not going to rebut Tony, so.
Okay. So I guess one question I have, actually, Mr. Fitch, I apologize. I should have asked this when you were up the first time. Staff had requested an open record period of 7, 7, and 7, kind of standard. I would like to get your position on that, because your position on that informs what happens to the 150-day clock.
You know, I think an open record for 7 days, period, would be fine. We don't have an opposition that's appeared, but that's my gut reaction to it.
Okay. The way the statute reads for initial evidentiary hearings is if there's any new evidence that is presented during the open record, participants have to have the ability to rebut that. So if we're going to do the initial 7, we'll need to do a rebuttal 7. And then, of course, you would have 7 days for any final legal argument.
Here's what I really think, is that if you had any questions based upon your review tonight, you come up with something, we'd be happy to try and answer those in writing. I don't see a need to supplement the record at all in 7 days, but to me, it would be only for the purpose of answering any questions you may have.
All right. Well, the questions I would specifically have in terms of where kind of on the evidentiary piece that I am sort of still scratching my head about. Let me pull up some other notes. I apologize for the quick delay. Oh, my computer screen just went blank for a second. Okay, here we go. I think you've answered the question orally about whether or not the parking access aisles meet minimum standards. What I heard you say was they do,
Yes.
but it would be nice to have some quantification of that so that there's evidence in the record that I can rely on.
Okay.
There's a question about the clear vision areas and whether or not they are adequate. That's on page 37 of the staff report and relates to, let me get the right reference. I think these are all within the same kind of section 18, 116.030 standards. Let's see. Another question I might have is on the, if you look on page 38 of the staff report, that's where staff addresses the parking lot design. again, I understand some of these are going to maybe dovetail off of your position that they are not maybe applicable at all because you're not reopening some of these issues. But I will tell you, I'm trying to figure out how we can, if we can write findings that actually state that, and whether or not for example, the parking lot design would be applicable to what's out there currently compared to the master plan piece. There's a discussion on page 47 of the staff report about whether or not the fire safety recommendations have been fully incorporated into the site plan. I believe you said you're working out all of the access issues with ODOT, but there's a lot of discussion on pages 49 and 50 about points of access to the site, and that shows up in a couple different areas after that as well. You answered my question about the solar farm and landscaping, bike parking. Finally, there was a reference that I couldn't find, and maybe I just didn't have the right citation to the record, but there was a reference about whether or not dry camping is allowed. And as I was looking through the record, that one kind of caught me off guard because I hadn't seen that reference before. So maybe address that in a written submittal as well. And again, these are areas where, at least my initial review of the record, it's hard to tell that they, from an evidentiary basis, have been addressed. And of course, you have your argument that they don't need to be. So I just want to make sure I don't leave any stone unturned.
Just to be clear, if it has to do with safety, we have no problem with it. Like the aisle width, the clear vision, those make sense. We will address these. I think they're all fairly straightforward, and I think we, in talking with Paul, we can probably get these resolved. Unfortunately, the only issue I have is time, because I'm going on vacation Friday. I'm wondering if something more like 2 weeks from today would be appropriate. And Nathaniel, I don't know where we're at on the time frame, but I think that should work.
Yeah, I can come up with those calculations here momentarily.
Okay.
We do have a toll in place as of now. I think if we can agree to a certain time limit set for the open record period, and if you are agreeable to those phases within the open record period, we could set a toll for that to count for that amount of time.
That'd be fine.
Okay.
So if we could have 2 weeks from tomorrow, that would be great, just because of the vacation schedule.
Yeah, that works for me. I'm not gonna, your time frame is fine. The reason I go through this exercise is because the county's code requires that, if it's a time frame that you either propose or agree to, that it would toll the 150-day clock. So you are more than entitled to take another couple weeks, and then we could do a week after that for rebuttal, a week after that for legal argument if you want it.
Okay, I appreciate that.
Okay. All right. We'll conclude the rebuttal piece of that then. And Mr. Miller, I guess kind of a standard question to staff is if you heard anything during the testimony that staff would like to respond to first before we get to the procedural aspect.
Staff has no further comments.
Okay. One question I had for you on that was the 2-year implementation of the, I think that was pretty standard language, but for a master plan that may or may not be, immediately constructed, the idea is to guide the future. If it is constructed, was it your intent that the conceptual plan be initiated within 2 years, or just that any part of the site plan sort of be implemented within 2 years?
So it would be the latter. Yeah, staff's understanding is that once you have an approval, if you initiate any portion of that site plan within the first 2 years, you have initiated.
All right. Thank you. Okay, it doesn't sound like there's any other comments, questions, or objections or procedural issues. Not seeing anything. So with that, we will we'll close the testimony portion of this. There's a request that I will grant to leave the open record period, or to leave the record open for a period of 2 weeks, which I think goes to May 2nd. If there's new evidence presented during that time period, participants will have a ability to respond to that for 7 days, which takes us to the 9th. And then if the applicant would like to have a final legal argument after that, close the record with no new evidence, that would be due on May 16th, is what I've calculated. So with those dates in mind, Mr. Miller, do you have a description of how people can submit information during those time periods? And was I accurate on those dates?
Yes, I can confirm those dates. We have May 2nd as being the end of the new evidence and testimony phase, May 9th for the end of the rebuttal phase, and then May 16th for applicants' final legal arguments. And if it's okay, I'd like to present instructions for how to submit during the open record period.
Please do.
Okay, so for the open record period, please keep in mind that all submittals should be addressed to me. For email submittals, use my email, nathaniel.miller@deschutes.org. The county does not retrieve information from website links or personal cloud storage devices. It is the responsibility of the individual to submit all evidence and testimony you want the hearings officer to consider. Any electronic submittals must be received by the county server by 4 p.m. Please do not wait until the last minute to submit your evidence and testimony. Thank you, Hearings Officer Brooks.
All right, thank you. With that, we will close the hearing, and the record is going to remain open. The written record will remain open as just described, and we will go off the record here at 7:12. Thanks, everyone.
Thank you.
Thank you.